Welcome to the webinar, Transgender Rights in the Workplace, the EEOC's Macy decision. My name is Sasha Buchert, and I'm a staff attorney with the Transgender Law Center. Our presenter today will be Ilona Turner, who is our legal director, who I'll introduce in a second. But I just wanted to let people know that today's webinar will be recorded and available on our website at transgenderlawcenter.org/EEOC. If you're an attorney and you're listening and are seeking bar credit, the one bar credit, general bar credit that's available, please contact me at Sasha at Transgender Law Center or record it in your self-study document. We'll be taking questions throughout the webinar in the question text box that you can see in your lower right-hand corner. We won't be taking questions orally, however, so just please submit your question, and at the end of the webinar, we'll go ahead and address those issues. Again, our presenter is going to be Ilona Turner, our legal director, and Ilona is the legal director for Transgender Law Center, where she oversees all of the organization's legal and policy work. Before joining Transgender Law Center in January 2012, she was a staff attorney at the National Center for Lesbian Rights. In the early 2000s, she worked as a lobbyist for Equality California, where she helped win groundbreaking legislation that prohibited housing and employment discrimination against transgender people. She has published numerous articles on transgender rights and received her JD from the University of California at Berkeley in 2006. Welcome, Ilona.
Great, thanks so much. Can you hear me? All right. So glad to be here. Thank you so much, Sasha. I'm really excited today to be talking about the Macy decision and where we are in terms of transgender rights in the workplace under federal law. We are just looking at the agenda for today. We're going to talk a little bit about the transgender community, who we are, a little bit of background for those who are listening who may not be as familiar as others. Give a little brief overview of our work here at Transgender Law Center, and then go into talking about Mia's case, the case that we represented her in and brought to the EEOC that led to the groundbreaking decision in Macy versus Department of Justice. Then we will go in and talk about what the decision means now that we have it, and finally talk about some tips for how to make a workplace inclusive for transgender employees, and then open it up for questions at the end. We'll save 10 or 15 minutes for that. All right, so we're going to start with some definitions. You know, again, just to make sure that we're all on the same page, you know, using the same terms, know what we mean by the same terms. So today I'm going to be using the phrase gender identity to refer to a person's internal, deeply felt sense of being male, female, or something else. Gender expression I'm using to mean, you know, the way that we present our gender to the world in terms of characteristics, behaviors, appearance, dress, mannerisms, way you speak, all of those things that are perceived by others as masculine or feminine. Now, the survey that's the images at the bottom of this page come from a big national study, the biggest survey ever done of the transgender community here in the United States, called Injustice at Every Turn. That was from 2009. And it was very revealing, particularly around some pretty stark realities around the many challenges that transgender folks, unfortunately, still today do face across much of the country. These are across a wide range of areas of life, from our families to schools to trying to access identity documents, you know, just so that a person can get through life and not be harassed just for being who they are. Employment, you know, the subject of today's topic, accessing safe housing, how trans folks are treated in prisons and jails. That's a space where a whole lot of abuse takes place. Accessing public accommodations, which are, you know, businesses that serve the public, restaurants, stores, and health care, you know, just trying to access culturally competent health care for transition-related health needs and other health needs. This study showed that a startling 90% of transgender respondents said that they had experienced some kind of discrimination on the job. The transgender respondents were twice as likely to be unemployed as the general population. And for trans folks of color, that went up to 4 times the unemployment rate. Really, really staggering numbers, you know, and shows the real intersections and exacerbation of challenges that folks face at the intersections of racism and transphobia. Transgender folks in the survey were 4 times as likely to live in extreme poverty. 41% had attempted suicide at some point, which is a really shocking number given that the average population number is something close to 1%. So that is a really, really stark disparity. And finally, that the transgender folks who responded were vastly overrepresented in the homeless population. So that's kind of the bad news. On the other side, though, you know, this is a community that is tremendously resilient, and finding all kinds of ways to fight back, to build community, to build a movement. And it has been a movement that has made tremendous progress, really, really astonishing progress in recent years, outpacing many of the sort of social justice movements that have come before. Even, I would argue, you know, the lesbian and gay rights movement in a lot of ways. So it's really exciting to be a part of this kind of transformation that we are witnessing and a part of right now. Now we've seen research coming out recently showing, you know, how some important factors to avoid those negative outcomes that were described on the previous slides. One really critical factor is family acceptance. That when families accept and love their young transgender youth, that has a dramatic impact on reducing those kinds of negative life outcomes. Additionally, the studies have showed that those who transition, who are able to be themselves publicly, are a lot more comfortable at work and, again, avoid a lot of those problems that people otherwise face. And some of the most exciting progress that we've seen, well, maybe it's just exciting to me as a lawyer, but it really is pretty phenomenal, has been in the realm of legal protections. And in particular, federal courts have been increasingly holding that transgender people are protected by prohibitions on discrimination based on sex. And that is something that has been really taking off in the last few years, and in particular is what has led to the sort of most recent pinnacle in that trend was the decision issued in the Macy decision that we just that we are here to talk about today. Now, you know, another great sign in that trend is the many states that have been enacting laws that explicitly protect transgender and gender nonconforming folks from discrimination. Right now we have 17 states and the District of Columbia that have adopted laws like that. And they're all listed right there. I wanted to talk just briefly about, you know, who we are at Transgender Law Center. We were founded in 2002. We are currently actually the largest transgender organization in the country, which is kind of cool. You know, I would think actually probably in the world as well. You know, it's a pretty small movement, and we're just so honored to be a part of it and able to help lead along with so many of you. We do engage in a really intentionally multidisciplinary approach to our work. You know, even though we have Law Center in our name, we're not strictly a legal services organization. We do some direct legal services, particularly, you know, through our legal helpline. We engage in impact litigation in cases that are carefully selected to move the law forward. And we do policy advocacy, you know, lobbying for new laws or regulations that are going to make a difference in trans people's lives. We do trainings, know your rights trainings, trainings for employers, trainings for lawyers about the law, trainings for healthcare professionals about, you know, what their legal obligations are, what their legal rights are, and how to competently work with trans folks. And we also engage in really intentional movement building, because we know that we can't do this alone. In part of that, we have a regular national summit that we bring together, National Leadership Summit, that brings together hundreds of trans folks from across the country. And hope many of you will be able to join us for that if you have not in previous years. It's a lot of fun. The issues that we focus on are primarily economic justice, including employment access issues, and healthcare access. And our legal helpline that I mentioned a minute ago, really proud of that. It provides information and kind of individualized advocacy for something like 2,500 callers every year. It's really, you know, I'm just really proud to be a part of that, and, you know, to know that we're touching so many lives and helping get folks this critical information that they need to be able to advocate for themselves in many cases. So I'm going to talk now about Mia's case. Mia Macy, our client, was a very skilled police detective in Arizona. She was a ballistics expert, and she had trained with the Bureau of Alcohol, Tobacco, and Firearms, ATF, and she was actually essentially working for ATF, or very closely with ATF, even though she was, you know, nominally working as you know, through the police department, but she was working on ATF computers, you know, trained on those computers, doing very fancy ballistics tracking work that I couldn't even begin to understand. But she's super smart and super well trained, and so when she decided to apply for a job in-house at ATF, just kind of switch hats, keep doing basically the same work, but just wearing a different hat. And so she applied for this job actually at an ATF lab in Walnut Creek, California, and they told her, absolutely, the job's yours. You know, just need to go through basic background check, no big deal, some formalities, but it's yours. So she quit her job and moved with her family to California. Oh, and I should mention that when she did this, you know, up to this point in the story, she was presenting, you know, throughout her life as male, because this was before she began her transition to female. So she had worked as a police detective as male, and she applied for this. When she began the job application process, it was as male. So while they were moving, going through the background check process, Mia started undergoing her transition, and she went to court, she changed her legal name and gender, she got her ID documents updated, and then very shortly before the job was supposed to start, she called ATF and said, oh, by the way, I just wanted to let you know that I'm transitioning, I'm transgender, and so I'm going to be starting work as a woman, as Mia. And just, a few days later, they got back to her and said, oh, so sorry. Actually, it turns out that, funding for the position has been cut, so there's no more job. Although later, she actually found out that actually somebody else had been hired for the job, somebody who had far less experience. And as a result of all this, she had moved all the way across the country, lost her job that had been promised to her, and her family couldn't make their mortgage payments and lost their home to foreclosure. It was really, really difficult time for them. Now, fortunately, Mia is really, really smart, and her skills as a detective came in handy. She knew that something was not right about what had gone down. The timing was just way too fishy, and so she was pretty sure that this had something to do with her telling them that she was transgender. So she got in touch with Transgender Law Center, worked with my colleague Matt Wood at the beginning, and Matt helped her file an EEO complaint, like a discrimination complaint, with the agency itself, with ATF, alleging that it had unlawfully discriminated against her based on her sex under Title VII, which is the federal sex discrimination law. Now, ATF refused to even process that complaint. It said that no, in its opinion, Title VII sex discrimination did not apply to transgender employees. Had nothing to do with them because it didn't say, I guess because it doesn't say transgender anywhere explicitly in the law. And so they just, said, nope, we're not processing this complaint. And so we stepped in to appeal that decision to the EEOC, which is the Federal Equal Employment Opportunity Commission. And that is the agency that oversees the whole federal government's kind of employment discrimination enforcement, and hears appeals of this type from individual agencies when it's being claimed that they are not following the law the way they should. So a little bit of background, the law we're talking about, Title VII, that means Title VII of the Civil Rights Act of 1964, and that's the federal law that prohibits employment discrimination that's based on race, sex, color, religion, and national origin. Title VII applies to all federal employees and to private employers that have 15 or more employees. The way that that Title VII has been interpreted in the courts over the last close to 30 years has made it very, very clear that gender nonconforming people and transgender people are protected by Title VII's prohibition of sex discrimination. So the first sort of seminal case in this area was the Supreme Court's decision in 1989 in Pricewaterhouse versus Hopkins. That was a case brought by I'd say a gender nonconforming female employee who appeared too masculine to her supervisors. They turned her down for a promotion in this accounting firm, telling her that she needed to wear makeup, wear dresses, get her hair styled, and go to charm school if she wanted to be considered for this promotion. So really offensive stuff. And the Supreme Court held that that was a form of sex discrimination, that discriminating against somebody because they don't fit your ideas of gender stereotypes, your ideas of what a woman ought to be like or what a man ought to be like, that is taking that person's sex, that person's gender into account in some way for this employment decision, and that is exactly what Title VII prohibits. So that seemed very straightforward. Unfortunately, it was something like 15 years later. It took another 15 years until the first federal appellate court, in this case the Sixth Circuit in the Midwest, applied that logic to a case brought by a transgender plaintiff under Title VII. And that was the case of Smith v. City of Salem, involved a transgender firefighter who was a transgender woman. She was fired soon after she began her transition. And that court said that, you know, Price Waterhouse clearly applies here, that she was fired for, in some way, going against the employer's ideas of gender stereotypes about what a man ought to be like, and so upheld her claim in that case. A couple of other sort of really significant decisions in this area just from the last couple of years. Schroer v. Billington was a case from the Federal District Court in Washington, D.C. in 2008. That was a really important and interesting decision where the district court held that discrimination against someone for being transgender is literally a form of sex discrimination. This judge basically said that you didn't have to go through the whole gender stereotyping theory in order to find that a transgender person was protected by Title VII's prohibition of sex discrimination. That just the fact that someone is transgender is enough. And the judge made an analogy to discrimination based on religion, saying that if an employer didn't have any problem with Jews and didn't have any problem with Christians as employees, but didn't like converts, so fired somebody for converting from Christianity to Judaism, say, that would obviously still be a form of discrimination based on religion, right? Nobody would argue with that. And so here, just because an employer, doesn't discriminate against cisgender men as a class and doesn't discriminate against cisgender women as a class, doesn't mean that they're not engaging in sex discrimination when they fire an employee for transitioning from one sex to the other. So that seemed like a really powerful argument and an important sort of intellectual move in the development of this, the case law in this area. And then finally, pretty recently, the 11th Circuit Court of Appeals, Federal Court of Appeals, down in the southeast, including Florida and Georgia, fairly conservative court, fairly conservative panel, but actually held unanimously, and this was a case brought by Lambda Legal. The Schroer case was brought by the ACLU. The 11th Circuit Court applied the gender stereotyping theory and held that the trans employee was protected by Title VII, and came pretty close, but stopped just a hair short of saying that to be transgender entitles you to sort of per se protection under these sex discrimination laws. They suggested, but didn't quite hold, that to be transgender is just sort of by definition always has something to do with violating, somebody's idea of gender stereotypes. So that was really interesting and important, and kind of the furthest decision that we had seen yet from a federal circuit court. Then we come to the EEOC's decision in the Macy case. So that decision built on all those previous cases that I was just mentioning. And on April 20th of last year, 2012, the EEOC issued its unanimous decision. All 5 commissioners signed on in the case Macy v. Department of Justice. And in that case, the EEOC held for the first time that discrimination against transgender people is unlawful sex discrimination under Title VII. Again, some of these other courts had held that, but the EEOC hadn't done so until this point. Now, Macy was the furthest reaching decision of all of these ones that we've seen. it was incredibly well researched and well written, and it goes through basically all of the potential theories, including the religion analogy and gender stereotyping and the sort of literal sex discrimination. And it says that, yes, all of those actually are viable theories, and just whatever theory you use, discrimination against someone who's transgender is by definition sex discrimination. So whether you're thinking about that as based on gender stereotypes or their gender transition or simply having a transgender identity or transgender status, all of that is just automatically counts as sex discrimination. And this is a quote from the decision. Just, makes me so happy to read it. Such ringing language. We conclude that intentional discrimination against a transgender individual because that person is transgender is by definition discrimination based on sex, and such discrimination therefore violates Title VII. Maybe for non-lawyers it will be hard to have quite the same level of appreciation, but that is something, that quote, that language, that holding is something that we had been fighting for decades to get courts to recognize, and the fact that not just any court, but the EEOC itself, the very agency that is in charge of interpreting and enforcing federal non-discrimination laws, that they agreed with that and put that out there in such strong, clear terms, was really astounding, and I hope will be incredibly, go on to be very influential in the further development of this, this issue in the courts. So, following that decision, what the decision actually did, it was deciding this question of law. Is a transgender person, is
muted.
This situation entitled to bring this case forward? Because remember, the ATF had refused to even process her complaint, so they hadn't yet investigated, they hadn't yet done any looking into the facts. They had just refused it just from the very, very beginning. So this was the EEOC saying, yes, the law does prohibit this. Now, ATF, you've got to go back and conduct an investigation, and this is the law that you have to apply to whatever you find. So if you find that she, in fact, was lost the job because she is transgender, then that was a violation of Title VII. And we were really thrilled to see that in July 2013, ATF, or its parent agency, Department of Justice, finished the investigation and concluded that, yes, ATF had discriminated against Mia and awarded her damages. And she was represented in that and part of the process by our friends at the law firm of Lewis & Feinberg here in Oakland. They did a really terrific job. So, what does this decision mean for the rest of us? It's just so tremendously exciting and game-changing. It's hard to even put into words. It changes things dramatically for both transgender employees and employers, all employers across the United States. As I said, this is the first time that the EEOC has held that transgender people are protected under federal law. And this is important because the EEOC is the agency. These are the folks who are charged with enforcing and interpreting federal discrimination laws across the country. And so this will be extremely important in those 33 states that still lack explicit state laws that prohibit discrimination based on gender identity or gender expression. And really this is, this decision can be seen as a tipping point. As I was indicating, there has definitely been a very strong, very clear trend in court decisions pointing this way already. So we already felt pretty darn confident about this theory, but this has just absolutely put the final nail in that and really given it the EEOC's stamp of approval, which is incredibly significant. And we've been seeing ever since that decision came down, ever since the week that decision came down, a slew of articles going out from law firms and sort of HR magazines and just all the sort of business journals in the world alerting folks, alerting companies everywhere that this is happening. Whoa, check it out. The EEOC has spoken. This is a big deal now. This is something we have to pay attention to. If you have transgender employees, you really need to shape up and make sure you have policies in place, non-discrimination policies, because you could be on the hook otherwise. And they didn't do that with any of the previous decisions. It was this kind of significant decision from this agency that really made them take notice in a way that they hadn't needed to before. So it was really thrilling to see and kind of, exciting to have had a small hand in that. So the EEOC, why does it matter that the EEOC made this decision? So this decision is now the official policy of the EEOC, again, the Federal Equal Employment Opportunity Commission. The EEOC has sort of two sets of powers. It has different powers over federal agencies and federal contractors versus its powers over private employers and state and local governments. For federal agencies and federal contractors, the EEOC sort of has a stronger, more direct role. It actually sets the policy, sets their non-discrimination policies, and it can adjudicate, it can decide complaints and issue awards of damages. For private employers and state and local governments, the EEOC's role is a little bit different. It can accept complaints in field offices, 50-something field offices around the country, and then it can investigate those. It has a large staff of investigators and mediators. They can mediate complaints between the employee and the company. And the EEOC also has a cadre of attorneys who can go out and represent individuals with employment discrimination claims in court. That the ones that they think have particular merit, they will go out and represent you in court. But they can only do that, unfortunately, for a small portion of all the complaints that are filed. In order to just a little bit about how one files an EEOC complaint, and Transgender Law Center actually has a whole publication on this. It's called Know Your Rights, Filing an Employment Discrimination Complaint with the EEOC. It's available on our website, and we'll make sure to put a link to it on the page on our website with this webinar. And it goes into more detail about how to file this type of complaint. But for federal employees and job applicants, what you do is you first need to file the complaint within your agency with the agency's EEO counselor. You've got a 45-day time limit to get that in from the sort of last bad action against you. For private sector employees or for job applicants, you file your complaint in a field office of the EEOC, and you've got a 180-day time limit to do so, which can go up to 300 days if there is a similar state law. And you have the option to file that as well with the state agency. If your state, like here in California, we have this California Department of Fair Employment and Housing that you could file, jointly with both of those agencies if you wish to. This decision, the EEOC decision in Macy, is incredibly significant, but in a lot of ways it's kind of the beginning, not the end of a process, right? Because it opens up a lot of areas where we really need future guidance. Additional guidance that may come from future cases that are decided by the EEOC or by courts bit by bit. This establishes the broad principle that it's unlawful to fire somebody or turn them down for a job just because they're transgender, but we will need at some point specific guidance about what does it mean? What does that mean for accessing bathrooms and sex-segregated jobs? Are lesbian, gay, and bisexual people who are discriminated against also entitled to protection under these sex discrimination laws? Because what happens to them when somebody doesn't like that a man is married to another man as opposed to being married to a woman, isn't that also taking sex into account in a way that the EEOC has so clearly said is forbidden? So seeing if we can get protection for the same sort of, by definition, protection for sexual orientation discrimination that we now have for gender identity discrimination. Looking at what kind of support employees need around or are entitled to around transitioning, looking at the lawfulness or unlawfulness of healthcare exclusions in employee health benefit plans, and I'd like to see some guidance looking at what is defining specifically what harassment can look like in the context of a transgender employee. For instance, a lot of folks that call us and people that we've worked with have one of the main forms of harassment that they experience is being called by the wrong pronoun intentionally and repeatedly. And that's something that a judge or lawyer who's never worked with a transgender person before, never known a transgender person before, might not recognize as really incredibly damaging and hurtful and offensive as it is, and as it is likely intended to be by the person who's saying it. So it would be good to get some guidance around that we can, show to employers to further make the case that they really need to be having employee policies in place to make sure that that kind of thing is prevented. But basically, the Macy decision, the basic principle is super clear, and that's what I love about it, that discriminating against an employee because they're transgender or otherwise in any way taking into account an employee's sex, an employee's gender on the job is sex discrimination, and it's unlawful under federal law. So we're going to talk just for a minute about some, sort of what can we do with this, as folks who may, work at a company or have connections to a company, or lawyers that are counsel for businesses. It's really in everybody's interest, right, to create inclusive workplaces. It's certainly in the company's interest to avoid these questions of legality and liability, potentially being on the hook if they're out of compliance. And it's just, it's clearly the best practice and the right thing. And so some ways that you can advocate for an inclusive workplace include advocating to add gender identity and expression explicitly into any non-discrimination policies, working with the employer to create explicit policies and procedures that will address some of the common issues that are faced by transgender people in the workplace. It can be really important to have training done for all levels of the organization on those policies and procedures, because if you just have policies and procedures that, sit in a binder somewhere and nobody really looks at them, they're not going to make that much of a difference in reality on the ground. So training can be really critical. And finally, you can advocate to make sure that the company's health insurance policies are trans inclusive and don't include those kinds of awful exclusions for transition-related care that we see so commonly. And all of those things will help the company get a score of 100 on the HRC Corporate Equality Index, which I love that that's a thing these days, and something that companies are really fighting for. They know that that marks them as a attractive, cutting edge, modern company that treats its employees well, and that not just LGBT folks, but allies and anyone who cares about equality and fairness would be interested in working at. So that's a really helpful tool, and one that we like to take advantage of in advocating for these kinds of changes in workplaces. It makes good business sense for companies to do this sort of thing, to create an inclusive workplace that's welcoming for transgender and gender nonconforming folks. A survey that Transgender Law Center did a few years ago showed that transgender respondents were twice as likely to have a bachelor's degree than the average Californian. And furthermore, right now, 57% of Fortune 500 companies have non-discrimination policies that include gender identity and gender expression, and that's up from 3% of Fortune 500 companies in 2002. That is just a really amazing and astounding and encouraging jump in just 11 years. So we are just making just really unheard of headway on this issue in a really short amount of time. It's really, really encouraging. And then finally, the sort of business argument for this also is that it mitigates the employer's exposure to legal liability, for all the reasons that we've been spending most of this webinar talking about. This is the law. And if they are not ensuring that their transgender employees and job applicants are being treated fairly, then they could well be on the hook. And that has much deeper meaning now that the EEOC has issued this decision. And it's something that employers, frankly, need to know about. It's in their interest to know about it and to avoid that. And finally, just some kind of best practices, policies, tips for, how a workplace can be as inclusive as possible. Some of these are related to legal obligations, and some aren't, but regardless, let's just call them best practices. So with a transgender employee, or any employee, in fact, you should be referring to them by their preferred name and pronouns. And if you're not sure what their preference is, ask. Ask in private. That tends to be more appropriate. But it's always better to ask. Access to any kind of sex-segregated facilities, like bathrooms or locker rooms or sex-segregated job assignments, those should always be based on the person's gender identity, not what's between their legs, not what is on any particular legal document, but just how they identify. That is the best practice. That is the practice of many, many, many of those Fortune 500 companies that we were just talking about. It's just common sense. Any other policy is unwieldy and unfair. And this is what non-discrimination means. Non-discrimination means respecting who a person is. And finally, any workplace policies need to ensure that they are respecting privacy of transgender folks, both in terms of keeping any records confidential. Certainly, staff, HR staff, anybody who happens to learn that another coworker is transgender should not be sharing that information with other people, even if you think it's just the most exciting piece of news you've heard all year and just the best gossip that you can't wait to share at the lunchroom. it's really not appropriate. It's just not your information to share. You should really think of it as any other kind of piece of confidential information, whether that's about a medical condition or something about somebody's personal life. It's just not appropriate subject for gossip or sharing in any way without that person's permission. And also in terms of privacy, just remember the sort of common sense rules of courtesy. Don't ask a transgender person about their medical history. Don't ask, have you had the surgery yet? That's one we hear a lot. It's just, would you be asking, are you asking any of your other coworkers about their private medical history or what surgeries they may have had or what their genitals look like? That's a good rule of thumb. If you're not asking other people this, maybe think hard before asking something like that about a transgender coworker. That is the end of our slides. We're moving on to, we've got a little bit of time left for questions and answers. Sasha, do we have any that have
unmuted?
I think they're coming in via text, right? Oh, hold on one second. Sorry. Sasha was talking, but I think she might have been on mute, so we're going to do that one more time.
Hi. Sorry about that, everyone. So there's a lot of questions that came in, and some of them dig pretty deeply into some legal issues that we don't have the space to talk about here. So if you could just email your questions to me directly at Sasha at Transgender Law Center, I'd be glad to give you a full response. But we do have a lot of questions, and some of them are repeated questions, so I'm going to address those firstly. The first was, this is a question that came up 2 or 3 times, that as a matter of administrative law, isn't Macy an interpretive decision and therefore not have the effect of force on law?
As a matter of administrative law, isn't Macy an interpretive rule and doesn't have the force of law? No, that is not the case. The Macy decision is a legal decision issued in an adjudicative capacity by the Commission, the Equal Employment Opportunity Commission. It's not a rule, or it's not in the same category as sort of written guidance that the EEOC sometimes puts out. It was a very thoughtful decision issued after, extensive briefing and fact-finding. It is absolutely entitled to the force of law. That is why, in fact, she was able to get the damage award at the end of the process. So, yep, that is how that works. What else do we have?
Great, thanks. Yeah, another question that came up a couple of times was the issue of states without express non-discrimination protections for gender identity. And the question is, how can those folks who are advocating for, against employment discrimination use the Macy decision, by the EEOC to their approval to protect transgender employees in those states?
How can, sorry, one more time. How can they use the Macy decision to protect transgender employees? Well, yeah, the Macy decision is going to be the most relevant and helpful for the folks in those 33 states that don't have explicit non-discrimination protections enacted in state law. So people in those states need to know that they are in fact protected under federal law. And again, this is where the publication that we have about how to file discrimination complaints with the EEOC would be very handy. And just refer to that link on our website. We should be educating the community about the fact that these rights exist, and that if folks encounter problems, that they should be filing complaints with the EEOC, which will then go ahead and investigate the complaint and mediate the complaint and provide them an avenue to court, either with a private attorney that they find or with an EEOC staff attorney for a small number of cases. But yes, this decision opens the door for all of that, and none of that was happening prior to this decision. So just one more reason that it's incredibly exciting.
Thanks, Ilona. Another question that came up was the issue of whether the EEOC decision, the Macy decision, applies to faith-based organizations or religious organizations who have employees.
There is a whole line of cases under federal law about when religious organizations, churches, and sort of, or companies that are closely affiliated with religions, like, church-owned hospitals, when they are covered by Title VII and when they are not. And so it's pretty complicated, and might be better to follow up if you have a specific situation arising. We'd be happy to help advise. But basically there is some exemption written into Title VII for religious-based employers. It's not a the Bible bookstore that has happens to have religiously affiliated owners or employees. It's an organization that is itself a religion, or very, very closely associated with one. And it has to do with, the First Amendment, wanting to steer clear of violations of the First Amendment, the free exercise of religion. But it's pretty complicated, and probably better to address on a case-by-case question, if that's all right.
Great, thank you. Let's see. Another question that came up was the question of one person asked that if a person were to receive a letter for employment, offering employment, and they hadn't officially accepted, and then their trans status was revealed, whether or not that would be a violation of Title VII.
Well, it would be if the offer were taken back just because the person is trans. And so it seems like that would, in a lot of cases, that would become a factual question, right? If it was, and that was basically the question in Mia's case, right? It was not totally clear. The agency was saying, oh no, it was just a coincidence, that she told us she was trans, and then we withdrew the job, but those two points in time had nothing to do with one another. It's just that we found out that we didn't have the funding, and so we wanted to go with this other guy. And there were supposed to be 2 positions, but actually there was only 1 position. So we went with this other guy. But then you have to really drill down into the facts. Like, okay, but why did they make this decision? If they were, in fact, it sounds like in the fact pattern, if they did, in fact, pull the job offer, even if the person hadn't accepted, or that doesn't matter. But if they removed the person from the possibility of getting a job just because they were trans, or if that seems to be what was happening, you don't always know that until you can get in and do a little fact finding, either from the the EEOC investigating, or once a lawsuit has started. But absolutely, that is the kind of thing that is squarely prohibited by Title VII.
And another question that came up was the issue of if Macy has created these protections that weren't there before under Title VII, why do we need ENDA? Basically, is the question.
Yeah, that's a great question. You know, we definitely get that question a lot. ENDA is going to be really, really important. You know, we had an experience here in California a couple years ago where we had non-discrimination protections in the law for something like 10 years, but they were hidden, and we had managed to get them passed. This was actually when I was working as a lobbyist for Equality California in Sacramento back in the early 2000s, and we had managed to get them passed, but through a very convoluted, kind of hidden way, and they were, you know, it was sort of done through this odd, convoluted definition of gender that was really hard for anybody to understand, and it was buried in the penal code and the hate crimes law, and so we referred over to it, and it was basically like some kind of, you know, maze game to even get to the statute. So basically, you know, it was great to have the protections, but nobody knew that they existed. Certainly employers didn't know. But then just last year, or actually in 2011, went into effect the beginning of 2012, we passed a law that made those protections explicit throughout California law. We updated every single non-discrimination law, which there are apparently, you know, hundreds of throughout the whole codes. Everywhere that it said, you know, race, sex, religion, we added in and gender and gender identity and gender expression. And that made a huge difference just because of making that one little change, which didn't actually change the substance of the law, the legal protections that are available to people. But now it was explicit. Now people could see it and could really easily understand it, and all of a sudden it was on every single poster that goes out. It was on our poster that we received, you know, that hangs in our kitchen, our office kitchen, you know, listing your rights as an employee, and it went out on all the posters, all the official posters, so that employees now were on notice, employers were on notice. It had the same effect, just like when the Macy decision came out, you know, it sort of like being broadcast out to all the, you know, employer associations and lawyers that represent employers and so forth, saying, by the way, this is a big thing now. You have to pay attention to it. And so ENDA would do that in just an even bigger way. It would make it absolutely crystal clear, because right now, unfortunately, we have a huge, huge uphill battle ahead of us in trying to get the word out about these protections to both the trans community and lawyers and employers. You know, we're doing our best, and the EEOC is trying to get the word out, and, you know, all the LGBT legal groups are, but none of that can have nearly the same kind of effect as the momentum and the sort of communication that would just happen naturally around the passage of ENDA. So that's the main reason that I think it's absolutely critical that we get that. Not to mention the protection it will provide, you know, just firming up for sure that sexual orientation is covered under sex discrimination. And it also takes away the possibility, you know, there's still always the chance that the Supreme Court could, in theory, take up a transgender employee case and decide it against a trans employee, say that there is no protection under Title VII. That seems extremely, extremely unlikely to happen, but it is a theoretical possibility. But if a law like ENDA were passed, then that possibility would be gone. You know, it would just be 100% settled for good that we have these protections. So that's why I'm really, really hoping that we can get ENDA passed either this year or in the next couple of years. It's really, our job's not going to be done until that's in place. I think we are just about at the end of the hour, so we should probably wrap up.
Thank you so much, Ilona, and thank you so much, everyone, for listening. A lot of questions about the PowerPoint. Yes, the recording and the PowerPoint will be located on our website probably later this week, but definitely will be accessible, and it'll be at transgenderlawcenter.org /EEOC. And I just want to remind folks that are attorneys out there that are looking for bar credit to, either do it as a self-study credit or to contact me and I'll send you a certificate. And also to remind folks that we have a helpline that addresses, legal issues impacting trans folks, ranging from identity documents to healthcare, employment, et cetera. But I just want to give a huge thank you to our presenter, Ilona, again, for presenting the webinar today, and thank you all so much. And please email me your questions at Sasha, S-A-S-H-A, @transgenderlawcenter.org, and we'll be responding.